asked to give a snapshot of developments or recent developments in the GCC. And I'll try to do that within the coming 10 minutes. So pardon me if I sprint through those. But I thought it would be appropriate to start with a bit of history. Now, and I think probably all of you already know that during the 1950s and 60s, and possibly the 70s, there had been a number of arbitration cases commenced against Arab states, particularly in the GCC. And many of those were, the awards resulting of those arbitrations were unfortunate. And the reason why I tend to characterize them as unfortunate is not necessarily that the tribunals found against the Arab states, but rather because the manner in which those tribunals had addressed certain aspects of the case, for example, governing law, was indeed unfortunate. I think commentators now simply characterize them as wrong. In any event, as a result of those cases, you don't need to worry about the slides. As a result of those cases, there was a significant amount of apprehension towards arbitration as a means of settling commercial disputes. And some would say justifiable. I'm of that view as well. But in any event, that was the result and the demeanor through sort of the mid-20th century. But if we fast forward to the 1990s and possibly early 2000s, that sense of apprehension was diminishing. And that was replaced by a de facto acceptance of arbitration as a means of settling commercial disputes. People can argue about the reasons, but obviously the realization and recognition by those GCC states that if you're going to prohibit the use of arbitration for settling commercial disputes with a foreign ingredient, as some of them did, or if you're going to simply prohibit any government, state, or state contracts from having arbitration like Saudi Arabia did, you will not be able to attract foreign investors. So as a result of that, partly, there was that change of demeanor. So that's a bit of history I just wanted to put in context so that when I talk about the developments now, we can actually see how that initial acceptance transformed to a large degree to actually a preference of arbitration and the use of arbitration, even promotion of the use of arbitration for settling commercial contracts. These were probably the infamous cases where those unfortunate awards were issued. And many of you will already know what I'm talking about. In any event, so the first development I wanted to touch on quickly, and actually it's more of a phenomenon, it was the proliferation of the arbitration institutions or the establishment of arbitration institutions throughout the Middle East. Now, I've just mentioned or listed a few of those. There are many more. Obviously, some of them are sector-focused, and others are geographically focused. They offer users various options, and the rules are generally up to date. But what ultimately this all means is that the jurisdictions, the various jurisdictions throughout the GCC seem to recognize, or for right or wrong, that if you have an arbitration institution, if you promote the use of arbitration, then that will cause investors to come in. Again, that might be right, but that might be wrong. But in any event, that is clear evidence of that preference, that promotion of arbitration and the use of it in the Middle East. Another interesting development has been the development of laws throughout the Middle East. Now, many of you will know that in the recent years, Bahrain has issued a new arbitration law, which literally simply says, refer to the UNCITRAL model law, very interesting law. But that is what the law says. And again, that's a step towards the right direction, a step towards creating at least the legal infrastructure for the use of arbitration. Saudi Arabia amended its infamously challenging law a few years ago as well. They're about to issue the ministerial decree interpreting the law. The IFC, as a separate jurisdiction within the UAE, has its own arbitration laws, which is again modeled after the UNCITRAL model law. Only recently, ADGM, the free zone in Abu Dhabi, also has and promulgated its own arbitration regulations. Qatar is about to issue its. UAE has always been on the verge of issuing a federal arbitration law. So there has been a lot of, again, developments in the law, the infrastructure to promote arbitration. Now, having said the positive parts, I'm forced to talk about the 257 that Mark raised, and I'm sure many of you might have questions about it, which we can deal with in the Q&A part. But indeed, that article, that amendment of the law, is quite unfortunate, and the complexity or the problematic aspect of it is that there's no criteria for that impartiality or independence cited in the law. So any lawyer thinking that he would want to derail proceedings or delay them or put pressure on an arbitrator or an expert can simply invoke the law. And technically speaking, there's no criteria. So you would say, well, you granted an extension to this party, but you haven't granted an extension to my client. You're impartial. Now, the law does not require any mens rea, so there's no intention or requirement for intentionally being impartial. Unconscious bias technically is caught under the article, which is absurd completely. But that's what the article says, and we will see how it will be exploited. My understanding, and there are, as Mark said, there has been a significant amount of lobbying to repeal the article, and without breaking, any confidentiality, but there indeed is understanding on the part of the legislature, and we have been told that the process of repealing it is actually started. So that's positive news, and hopefully the negative impact will quickly be avoided. Another issue is the approach of the courts. Now, all of you will know that winning an arbitral award and getting that positive award, favorable award, is only half of the battle. It's just an expensive piece of paper. It's only when you actually enforce that award against the assets of the other party, or if it voluntarily pays up, which I haven't come across that often, especially in this region. You have to enforce it against those assets forcibly. And you can't do that except if the courts of the jurisdiction where the assets are assist you. Now, we have to confess that the courts in the region have not necessarily been helpful in respect of arbitration and quickly recognizing and enforcing arbitral awards. However, again, recently we have seen trends that are promising. Obviously, there is the DIFC courts, which the bench of that court is all made up of retired English court judges who are all known to be arbitration friendly, and as I said, there's a model law applicable there. So enforcement through that route usually is quick, is efficient, and it does happen. Dubai courts, usually the Court of Cassation, the highest court of the land, gets the answer right, but obviously some of you might have come across instances where, or read about instances where the Court of First Instance or the Court of Appeal comes up with interesting judgments in respect of arbitral awards and fails to properly and validly enforce them. But again, as I said, the Court of Cassation does get it right, and there has been a few promising developments in the court's approach towards arbitration. So we're seeing slow but consistent development. We've also seen a few promising developments in Saudi Arabia. I was actually told by a member of an international law firm a few months ago that they successfully enforced a foreign arbitral award in Saudi Arabia in 3 months. So that's again, very promising. Saudi Arabia if you would scale the GCC countries in terms of difficulty enforcing foreign water awards, Saudi Arabia would probably be on the top of the list. And if you get it through that jurisdiction in 3 months, that is indeed a very promising result. Quickly, I'm conscious that I'm running out of time. Arab Spring. Now, as a result of Arab Spring, in the course of the past 3-4 years, because of the expropriation done by governments, particularly in Egypt and Tunisia, because of cancellation of contracts relating to concessions, etc., there have been a significant amount of investment treaty arbitrations. And I think the reason why I'm talking about this development particularly is that when you compare the reaction of those states to reactions of, for example, South American states, when similar scenarios happened, when they were faced with significant amount of investment treaty arbitrations, they canceled investment treaties, they simply ignored arbitration clauses. Actually, when you look at how the Egyptian government reacted, how the Tunisian government reacted, actually they accepted, they recognized, they adhered to the arbitration clauses, they actually defended the cases and appeared in the arbitration, so there's more of a proactive approach. So that in itself, again, is a very positive indication. The states are not running away from arbitration or sort of playing the sort of a shaming game of saying arbitrations or sort of all partial to the north, but rather there's an acceptance of the use of arbitration and adherence to the process. So these are quickly the developments that I want to touch on. Now, a quick expectation for the future. UAE, I mentioned there's that much anticipated arbitration law. We'll yet to see how it comes out or when it comes out. There's the hopeful repeal of Article 257. In Saudi Arabia, we are waiting for that ministerial degree of the arbitration law explaining how it will be applicable, and also with the new arbitration center there, again, seeing how people will react and whether the government and international parties will sign up for that local arbitration center. In Egypt, I mentioned that the government had accepted the process of arbitration, had appeared before the relevant tribunals, but the question will become whether the local courts recognize and enforce those potentially unfavorable awards. So that's, again, something to look out for in the coming years or months. Arbitration centers, I mentioned there have been a lot of them being established in the region. Only two in this year only have been established. So I think we haven't seen the last of it, and I think potentially more of them will be established. Reasons behind that, who knows? But I think it will be interesting to see how some of them survive, given the fact that there are far too many for a jurisdiction that big. And hopefully I'll address any questions that you have in the Q&A session. Thanks a lot.